welcome to How to Go Independent. I'm your host, Sean Kernan. We help financial advisors who are employees explore, examine, and consider independent business models. Today, I'm going to talk about a legal part of going independent, which is never the most fun part, at least for me and for most of us. And that is the amount of information that you're able to take, specifically if you're trying to comply with the broker protocol. So this is a topic that always comes up in our conversations with advisors looking to make a change. But it's hard to articulate and describe more generally because so much of this is interpretation and each advisor has to kind of make their own decisions on the risks they're willing to take or not take when they make a change. I decided to do an episode on this after coming across an article on Michael Kitz's blog published on August 22nd, 2016. So we'll have a link to that in the show notes and on the blog, our blog. The title of the post is Complying with the Broker Protocol When Changing Firms or Going Independent. And as a matter of background, I'm just going to read the executive summary. That way you've got it if you don't have a chance to read it yourself. And then make a few comments and give you a few high-level thoughts, and I'll try to keep it brief. So the executive summary reads as follows. Again, this is from Michael Kitz's blog. I'm reading word for word here. While advisors working at broker-dealers typically think of the clients they work with as their clients, the legal reality is that they are clients of the broker-dealer. That broker-dealer. This may be a distinction without a difference. But as soon as a broker wishes to change broker-dealers or break away to an independent RIA, significant issues arise, from violating employment contracts by soliciting clients for a new firm while you still work for a new one, to rules protecting client privacy that prevent a moving broker from taking any client information with them. In the early 2000s, litigation related to broker-dealer recruiting and changing broker-dealers had reached such a fever pitch. The major wirehouses, Smith Barney, Merrill Lynch, and UBS, executed a form of ceasefire treaty dubbed the Protocol for Broker Recruiting, and stipulating the terms under which a broker could depart a broker-dealer and take limited client information without spurring the litigation and temporary restraining orders that were common at the time. Since 2004, the broker protocol has expanded from the 3 founding firms to nearly 1,500 and is the essential roadmap for how a broker can leave their current broker-dealer in the cleanest and most efficient manner possible. The good news is that in the years since the broker protocol agreement was first signed, thousands of brokers have made successful transitions away from their original broker-dealer. However, the broker-dealers have still made it clear that any broker who does not fully and perfectly comply with the broker protocol may still be subject of aggressive lawsuits seeking to limit their actions. In this article, we look at the details of what the broker protocol is, what exactly brokers must do to comply with its terms and requirements, and the best practices and issues to consider when preparing for a transition away from a broker-dealer to another firm, or when going independent altogether. So that's Michael's executive summary. If you've ever read any of his stuff, you know he's extremely thorough, so this is a great article to read. I'm not going to quote it much more than that exact reading of his executive summary. Another resource on this post is several law firms that are familiar with these issues. 5 of them down at the bottom. Some that are specific to broker-dealer to broker-dealer change. Others that talk about going independent, setting up your own RIA, and then one that I guess is familiar with any transition. Just for clarification, if you hear the term broker-dealer and that doesn't sound like a familiar term with you, basically think that's just any firm that does brokerage business that's not advisory only, which the vast majority of employee firms are going to have a broker-dealer. Any wirehouse, any employee firm, any insurance-owned firm, any large regional. When I hear broker-dealer, I think employee firm, although they're not synonymous because I'm affiliated with a large independent broker-dealer. But in the event, when you hear broker-dealer, it's a different legal construct than an RIA. And so that's where the legal distinction comes in. In an RIA, the firm actually owns the relationships and the accounts, so to speak. They are accounts of the firm. I guess the same is true of the ones at the wirehouse or employee firm. The broker-dealer owns the accounts. They have legal responsibility. But again, as anyone who's been in this business for more than about 2 months understands, if you do a good job working with people, clients, usually they kind of buy us. They don't buy the firm. The firm might assist in them buying us, but very few people say, let me work with someone at XYZ firm, and I don't care who it is. It's usually, I like this person, and they've got, big name behind them, so they must be legit, and I'll go ahead and do business with them. At least that's my perspective. So when it comes to what information can you take and not take, again, I'm not an attorney. I don't play one on TV or on podcasts. So take this with several grains of salt. But read this article. Get guidance from whoever you're going to work with to help you make a move or consider a move, whether that's a broker-dealer that you'd be going to, an independent RIA. If you're going to set up your own RIA from scratch, definitely talk to an attorney. I think one of these on Michael's post would be a good place to start. Or if you have colleagues that have made a move, ask how they made these decisions on who to talk to. If they have attorneys or consultants. And then I think usually the best source of information, if you get enough of it, is other advisors who have done what you're looking to do. So, each experience is a one-time event, and so you can't count on that experience being exactly what you go through. But if you talk to enough people, I'd say the minimum sample size would be about 4 or 5. Ideally, double that. But if you don't want to spend the time or risk reaching out to that many people, that some combination of the people that would help you run your business and make the move. Again, they're going to have a bit of a sales motive to some degree, but if they're good, you'll be able to tell if they're trying to help you or just trying to get you to move. Hopefully they're trying to help you, and moving is part of that. Or maybe it's not, but if you determine it is, then hopefully they're not going to do anything to put you in hot water, because that wouldn't be good for their business either if they're not helping people be successful when they make a move. But I think your peers, people you've known that have done the same thing, and if you don't have any direct peers, you can find them indirectly. I'm happy to give you some ideas if you need help on how to track those people down, identify them, what characteristics to look for. But it's a complicated issue on what you can take. The protocol is pretty straightforward. A lot of times we tend to want to make things easier on our clients, especially if we're asking them to follow us. But you have to be extremely careful on how you do that. Again, I don't want to get into a lot of tips and tactics I've seen people use, because some of them probably are not within the letter of the law of the protocol. And I've seen people be very successful with them, but they're not always the risks aren't always worth the reward. Now, I will say in general, I don't see anybody going out of business over issues that have come up, or very few people. I read about it, I guess, in the industry press. But in general, for the run-of-the-mill advisor who's trying to help their clients, if they're not completely stupid about what they do, the clients want to work with them, and that's going to be that. And so people move. Maybe they get a nasty letter or two, the advisor that is, about, hey, you can't do that, or you're not supposed to do that. But I think a lot of it is just inexpensive scare tactics from a firm who doesn't want to spend the money, even though they have it. They probably have more than you do. They don't want to spend the money haggling. They don't want to make it look like they are throwing up roadblocks, even though they do, just in their culture in a lot of ways. Several firms that I'm aware of are just the way they talk about people that leave I'm kind of laughing because it's funny. I got an email back recently from someone who said, my firm pays more than anyone else, in case you didn't know. And this is an employee. So his numbers are, I know the source of his numbers, which are either his firm or maybe a magazine article, which doesn't include independents. It's just, he's pretty deep in the propaganda. So that kind of communication floats around, I'm sure, when people leave, no matter how great that person was the day before they left. So that that can happen. But I've only seen one or two cases personally where there was even some legal action threatened. The one case I'm aware of, someone settled. It cost them a little bit of money, but it was well worth it in the advisor's opinion and experience going forward. It just cost him a lot more time and stress than probably he wanted. But in that case, like most things, there's usually a story, and his explanation, he thought what happened was he had kind of gotten some access to the firm's leadership in doing a research project for a graduate degree that he felt it was almost like a spurned relationship of any kind. They were a bit vindictive. He was successful. He'd kind of been let behind the curtain a little bit in terms of how the firm operated. Again, I'm summarizing here, but so he ended up having to, I think, pay a little bit of money, but it was nothing substantial compared to the value he had created in his new business and how he was able to help his clients in more and different and better ways. So again, it was a temporary annoyance compared to a permanent value creation for his business and his clients. So I think that's I'll leave it there because there's so many what ifs. Just be aware if you do things that are against the protocol, you're taking some risks. We all take risks in starting our own business. We take risks, in getting into this industry because the success rate is not that high. And when it comes down to it, you kind of have to make your own business decision in terms of the risk reward. But make sure you get a lot of opinions because you could have the risk of getting legal action, but you could also have the risk of not having enough clients or as many as you should if you're not direct in. I guess the bigger picture is also communicating to clients about your move. But again, that's sort of a legal issue and it depends on who's interpreting it. But you also want to make sure you have enough clients. So those could be, if you don't do anything and you're safe on the notification and client information, you may not get sued, but you also might not have any clients. So again, there's this, you should be able to operate within the rules, and these days it's pretty easy to let people know where you are and they'll find you, and it's easy to communicate with people. And at the end of the day, clients will go where they want to go, and as it should be. So anyways, refer back to Michael's article in the show notes, or just go to search complying with the broker protocol when changing firms or going independent. That's August 22nd of 2016. And I think you'll find it useful. Thanks for joining me, and we'll talk to you next time.